has today presented its case before a seven-judge bench of the Supreme Court, led by Chief Justice Martha Koome, seeking to reinstate the Finance Act 2023. This follows its recent nullification by the Court of Appeal, and the government argues that the appeal is critical to maintaining stable operations as the Finance Act 2023 remains in force following the withdrawal of the 2024 Finance Bill. They warn that failing to uphold the act could lead to fiscal instability. Our reporter Vera Mora has the details.
In a joint request made on Tuesday before the seven-judge bench of the Apex Court, led by Chief Justice Martha Koome, the petitioners underscored the grave consequences of invalidating the Finance Act 2023. Professor Githu Muigai, representing the Attorney General and the Cabinet Secretary for the National Treasury, argued that the act is vital for maintaining the country's economic stability, warning that nullifying it could trigger fiscal crisis. Muigai emphasized that without the provision of the Finance Act, Kenya's ability to manage its budget and meet national debt obligations will be jeopardized, potentially leading to a debt default that will eventually disrupt government operations and affect the livelihood of ordinary Kenyans.
The judges are in holding that the framework for the housing levy as set out in Section 84 does not meet the requirement of Article 201, 206, and 210 of the Constitution, and the principles of good governance, transparency, and accountability required by Article 10, 2A, and C of the Constitution.
KRA taxes collected under Finance Act 2023-2024 include a total revenue of 2.4 trillion Kenyan shillings, excise tax of betting and gaming of 24.2 billion Kenyan shillings, domestic value-added tax of 314 billion Kenyan shillings, corruption tax of 278 billion Kenyan shillings, payee of 543 billion Kenyan shillings, domestic exercise of 73.6 billion Kenyan shillings, and a capital gain tax of 8.3 billion Kenyan shillings. The Attorney General and Treasury Cabinet Secretary also argued that the Court of Appeal's decision not to hamper the implementation of critical policies but also threaten the separation of power between the judiciary and the legislature. Among key arguments presented before the seven-judge of the Apex Court was the issue of affordable housing levy, which the Court of Appeal had deemed moot. If the Finance Act 2023 is nullified, several newly introduced taxes will be annulled, including the 5% withdrawal tax on digital content monetization, 16% VAT on petrol, kerosene, and aviation fuel, 32.5% payee for those earning between 500,000 Kenyan shillings and 800,000 Kenyan shillings monthly, and an 8% VAT on LPG, among others.
This Apex Court occupies a very critical position in the realization of the objectives and values of the Constitution, because it has the final power of interpretation and application of the Constitution, including the power to find any law, action, or omission that is inconsistent with the Constitution to be unconstitutional and therefore invalid, null, and void ab initio.
The respondents in the case, led by Busia Senator Okia Omtata, alongside 52 others, including the International Commission of Jurists, Katiba Institute, and the Kenya Human Rights Commission, have urged the Supreme Court to reject the government's appeal.